Quote, you heard this testimony. All of the abuse is done in the same fashion. Smith would rub his fingers in a circular motion on the vagina of each child, and he did so repeatedly. Now, where I come from, we call that sexual abuse. You can pretty it up all you want to, Judge. This is what you said at Mr. Micah's sentencing. These are your words, not mine. What I can say, you said, is that this is a very tragic situation of a person who has a lot of good in him. A lot of good in him. Having done a very reprehensible thing to two young children, causing extreme damage.
What you just watched is a perfect example of why Senator John Kennedy is one of the most effective questioners in the U.S. Senate. This wasn't grandstanding. This wasn't theatrics. This was Senator Kennedy doing what too many lawmakers refuse to do, forcing clarity. In this exchange, Senator John Kennedy takes on a judge nominee over something that sounds academic but has massive real-world consequences: how judges interpret the law. And what stood out to me immediately is how calmly, persistently, and precisely Senator Kennedy boxed this nominee into answering a very uncomfortable question. Because when judges start treating context and legislative intent as flexible tools, the law itself stops being stable. And Kennedy clearly wasn't going to let that slide. If you care about constitutional limits, judicial accountability, and whether judges follow the law as written or rewrite it, then you're in the right place. This is Congress Lens. I'm Audrey. If you want sharp breakdowns of congressional hearings without the spin, hit subscribe, like this video, and let's get into it.
You have more sympathy for the criminal than the victim, don't you?
Senator, I worked on behalf of victims of crime zealously as a prosecutor. As a judge, I listened carefully to understand impact on victims, and I have always take that into account.
Do you know Micah Smith?
Michael Smith, Senator?
Micah, M-I-C-H.
I don't believe I know a Micah Smith, Senator, no.
Okay. I bet the victims of Micah Smith remember Micah Smith. If you don't.
Senator, there was a defendant I sentenced named Michael Smith.
Mr. Smith molested a 4-year-old girl, didn't he?
Senator, he was convicted after trial of unlawful sexual contact under Maine law.
That's a nice way of putting it.
That was the charge, Senator.
Right. Mr. Smith molested a 9-year-old girl, didn't he?
Senator, again, he was convicted of unlawful sexual contact against 2 children. In that case, I did impose the sentence the state requested.
At oral argument, this is how Mr. Smith's conduct was described. Quote, you heard this testimony. All of the abuse is done in the same fashion. Smith would rub his fingers in a circular motion on the vagina of each child, and he did so repeatedly. Now, where I come from, we call that sexual abuse. You can pretty it up all you want to, Judge. This is what you said at Mr. Micah's sentencing. These are your words, not mine. What I can say, you said, is that this is a very tragic situation of a person who has a lot of good in him. A lot of good in him. Having done a very reprehensible thing to 2 young children, causing extreme damage. Did I read that correctly?
Senator, in that case, I imposed the sentence the state requested.
Did I read that, your quotation correctly?
Senator, That, I think, is a portion of what I said at sentencing. My focus was on...
But the words I read, are they correct?
That's what was reported in the paper, Senator. I have not seen a transcript of the sentencing.
I bet the victims remember, Judge. You might have forgotten, just like you forgot his name, but I bet the victims remember. And then you handed down a sentence. You gave Mr. Smith 12 years, but you suspended 6 of them, didn't you?
Senator, that was at the recommendation of the state because
but it was your ruling. Did you? Is that an accurate statement of your ruling?
Senator, I accepted the state's recommendation that 6 years should be suspended so that Mr. Smith would be required to participate in sex offender treatment.
I appreciate the lengthy explanation, but I think it's a pretty simple question. That was your sentence, right?
Yes, I imposed the sentence the state requested in that case.
Are you familiar with the Bangor Daily News?
I am the Bangor Daily News, Senator.
Right. Did you read the article they wrote, quote, light sentences send a message that domestic violence does not matter, end quote. You remember that article?
I have read it, Senator. I believe it mischaracterizes a case that is
That
described.
article was about you, wasn't it?
My recollection, Senator, is that it described several different cases. The case that I worked on that was described there, the defendant in that case was acquitted by a jury of the most serious conduct, and that was not reflected in that article. And so
the newspaper got it wrong.
That was an op-ed that I believe misunderstood what happened, which is the jury acquitted the defendant of the most serious conduct that he was charged with. I was not the fact finder in that case, and so at sentencing I was bound by the jury's verdict.
Let me ask you, I'm going to run out of time here. I wish I had more time for you, Ms. Campbell, but I've seen a lot of activist judges, and I'm not saying you're the most activist, but the list you're on, it sure doesn't take long to call the roll. Let me finish with this question. I'm going to end as I began, Judge Lopez. You have more sympathy for criminals than victims, don't you?
Senator, I have the support of the Maine Coalition to End Domestic Violence and the Maine Coalition Against Sexual Assault. I believe that support is a reflection of the work I did as a prosecutor as well as the care I take with cases involving victims as a judge.
You're embarrassed to answer my question, aren't you?
Now that you've watched the full exchange, let's talk about what really happened here. Because this was not a simple debate about legal theory. Senator John Kennedy wasn't confused. He wasn't fishing. He was exposing a contradiction that shows up again and again in judicial confirmations. The nominee starts with the safe answer, the text is paramount. And on paper, that sounds great. Everyone in Washington knows that's the answer you're supposed to give. But Kennedy doesn't stop there. He pushes on the obvious follow-up. If the text is so clear, clear as thunder on a summer night, as Kennedy puts it, why do judges still feel the need to rummage through legislative history? That's the heart of this exchange. Because legislative history is not law. It never passed the Senate. It never passed the House. It was never signed by the President. And Senator Kennedy is absolutely right to be skeptical of judges treating it like some hidden decoder ring. The nominee tries to walk a careful line, saying legislative history can provide context, but should never override the text. But Kennedy knows how this plays out in practice. Judges don't always use legislative history to confirm meaning. They use it to change meaning. And Kennedy calls that out without ever raising his voice. Then comes the key moment, the pivot to the Constitution. Senator Kennedy asks why judges are allowed to use the Federalist Papers when interpreting the Constitution but are supposedly warned away from legislative history when interpreting statutes. And this is where the nominee stumbles. The explanation turns into a semantic escape hatch. Well, that's different. The Constitution was publicly ratified. It's about original public meaning. And Kennedy shuts that down immediately. No, it's not. No, it's not. That interruption matters. Because Kennedy is pointing out something most Americans instinctively understand. Either history matters, or it doesn't. You can't say history is dangerous when it comes to statutes, but suddenly indispensable when it supports constitutional interpretations you like. And Kennedy's final question is devastating in its simplicity. If interpreting the Constitution is really just about history, why not let historians do it instead of judges? The nominee's answer, that judges apply legal history through analogical reasoning, basically proves Kennedy's point. This isn't neutral interpretation. It's judgment. It's discretion. And sometimes, it's ideology wearing a robe. Senator John Kennedy wasn't attacking textualism here. He was defending it. He was drawing a line between law passed by the people's representatives and opinions written after the fact. And that's why this exchange matters. Because once judges decide the text is optional, democracy is optional too. That's why Senator John Kennedy's questions weren't nitpicking. They were necessary. Let me know in the comments. Should legislative history ever outweigh the plain text of the law? This is Congress Lens. I'm Audrey. Thanks for watching.